Tonight, we bring you the new English requirements for the 485 graduate and student visas, the new law about the new 192 PR visa, and a comparison of the old GTE with its replacement, the GS. Hi, I'm Karl Konrad, and welcome to our weekly edition of Australian Immigration News. This program is proudly presented by Australian Immigration Law Services, the company I founded more than 25 years ago. We are the only channel that gives you insights and opinions based upon a quarter of a century of running a professional practice. New English language requirements were released only 2 days before its implementation for the 485 graduate visa and for the Student 500 visa. The most important issue regarding these new laws are, for the 485 visa, the English test result must not be more than 12 months old now. This has been reduced from the previous 3 years validity. It is crucial news because the 485 visa requires that English ability is met and evidenced when the visa is lodged. So what are the English level changes? For the Graduate Skilled 485 visa, the minimum score required for the IELTS test score increases from 6.0 overall to 6.5 or equivalent tests, with a minimum score of 5.5 for each component of the test. Alternatively, if you hold a passport from the usual set of English-speaking countries, then the waiver for the English test result continues as before. For student visas, the minimum score required for a student visa for an IELTS test score increases from 5.5 to 6.0 overall, or its equivalent. The minimum score required to undertake a package ELICOS from IELTS increases from 4.5 to 5.0. For students studying English only through ELICOS, there will be no change. And the test score required for students undertaking university foundation or pathway programs that deliver reputable English language training will be IELTS 5.5 or equivalent. This reduction of validity times for the English test result from 3 years down to 1 for the 485 visa seems more than a little absurd. Effectively, the government is broadcasting to the rest of the world they do not trust the quality of Australian education institutions to provide courses in Australia at a high standard of English. They might as well do this.
Attention everyone! Students who graduate from Australian universities with bachelor or master's degrees cannot be trusted to have basic English capacity.
In addition, the Home Affairs Minister assured the Australian public that they wanted to decrease the complexity of the visa application process, but these requirements now do the opposite. Depending upon the visa you apply for, there are now various levels of English test validity periods. The 485 has 1 year, student visas for 2 years, functional English for 1 year, and English points allocations for 3 years, and so it goes on. Isn't it obvious that if you wanted to decrease the complexity of obtaining the 485 visa, you would do away with English results altogether? Indeed, applicants who have completed an Australian qualification and met the Australian study requirement surely demonstrate sufficient English. Sadly, many people will not know that the English course requirements have changed from the 24th of March and will lodge their application using old English test results, assuming they are still valid for 3 years. And worse still, it also ensures that people whose student visas expire in the next 2 or 3 weeks but wish to apply for the 485 visa will struggle to obtain new test results in time. Why couldn't they just make this requirement start in July to give people a reasonable period to adapt? No, they just had to be nasty and give 1 day's notice. Unbelievable. And to top it off, the minister posted this message on Thursday as if it was something the government should be proud of. However, doing this to students who have spent so much money, time and effort in Australia, it's nothing to be proud about, Minister. For goodness sake, your department should try and adopt a more humane method of dealing with people. For student visa applicants, you have the advantage, for your higher English test result can be given after you have applied, or you may be eligible for a waiver anyway. Now, while international students in Australia are copping a beating from the federal government, our Pacific Island neighbours have been given the red carpets. The new 325 permanent residency pathway visa, called the Pacific Engagement Visa Subclass 192, starts on the 29th of March. The legislation has now been published. The 192 visa applicants can be inside or outside of Australia when they apply. It should be noted that if applicants intend to include a spouse or de facto partner, they must be included in the application when the visa is lodged. There will be no provision to add one during the processing period. If you are lucky enough to have your name pulled from the lottery, you will have a specified amount of time to make your application, and this will be stated in the invitation to apply. You will also need to have a suitable job offer letter from an Australian employer, but it is possible to provide this when you have been allocated a case officer after applying. No doubt there should be a certain degree of flexibility as to how long an applicant will be given to provide this letter. This job offer can be for the main applicant or your partner combined in the application. It needs to be a written offer of employment by an employer for a genuine position. An employment offer must ensure that the conditions and salary must not be less favourable than those offered to Australian citizens performing equivalent work at the same location. The applicant or applicants must have adequate means or access to adequate means to support themselves or each member of the family unit during the first 12 months in Australia. However, the legislation does not describe how much money would be required to demonstrate adequate means. I'm sure that will come later. Also, if an applicant has been in Australia or is in Australia, they must have substantially complied with the conditions of their last visa held. Those lucky enough to have the 192 visa granted can be in or outside of Australia at the time of grant. The DOA Minister Claire O'Neill has warned that the mass implementation of Condition 8503, no further stay, will be used on visitor visas to ensure people do not jump to a student visa after they arrive in Australia. In a statement released on Thursday, she said, to avoid visitor visas being used as a way to subvert offshore student visa integrity checks, the government will be increasing the imposition of no further stay conditions on visitor visas. If a prospective student is offshore and looking to come to Australia as a student, then they should apply for a student visa offshore. It is very likely that soon every visitor visa issued to non-ETA country passport holders under 40 years of age will come with Condition 8503. Whether the DOA will extend this to ETA passport holders is yet to be seen. Now, which one is better, the GTE versus the new GS? Last week, the sneak preview of the genuine student visa requirements resulted in the Australian universities hitting the panic button. An article in the Sydney Morning Herald reported on an emergency meeting of universities to discuss whether it was better not to provide offer letters to those in Australia who hold bridging visas and temporary working visas, such as the 482, 407 and graduate 485 visa holders. This story sent shockwaves through the industry. But is the new GS any different from the old GTE? Now, we all expected that the GS to be a relief from the old GTE it replaced, but unfortunately that has not been the case. This week the department released details of the GS, so let's take a look and compare the two. Using the department's website on the new GS as a guide, we quickly scroll through the requirements and compare them. Previous study in Australia, same as the GTE. Current employment, same. Circumstances in their home country or country of residence, same. Economic circumstances in home country or country of residence, same. How we assess GS, same as the GTE. Situations in their home country or country of residence, same. Potential situation in Australia, same. Value of the course to their future, same. Immigration history, same. And any other relevant matter, and you guessed it, the same. So it's clear the new GS is just a publicity stunt to make it look as if the minister is doing something to protect Australia from the student visa invasion. There is zero difference between the old version and the new. In another edition, I will demonstrate that using the GTE or the GS, you could refuse any student from any country if you wanted to. If they wanted to use it to refuse the 482, 407 and 485 visa holders and those on bridging visas, there was just as much reason to do so with the old GTE compared to the new GS requirements. Well, on that groundbreaking revelation, that's all for tonight. These are interesting times and even more changes heading our way. If you want to be sure you understand what it all means and make sure you don't miss any, don't forget to subscribe to this channel. Oh, by the way, there will not be a news show scheduled for next weekend, so you can all relax and enjoy the Easter break. I will be taking the motorhome out and enjoying the countryside. Have a great Easter, everyone, and take care out there, and I'll see you next time. So bye for now.